Hi everybody, I'm Michael Brady, partner and co-chair of the Warner Norcross and Judd Automotive Industry Group, and I'm a litigator. I handle supply chain litigation and counseling for automotive supplier clients all day, every day in what I do. In the last several years, we have had to address with a number of our clients and suppliers in the industry the question of when does it make sense to go from negotiating a supplier dispute with your customer or your own supplier into litigation? When does it make sense to file a lawsuit? And the check marks that we go through, I want you to keep in mind as you make this assessment for yourself. The number one issue is always going to be an assessment of your legal claims, legal defenses, what's the factual situation, and you need to have experienced automotive attorneys to help you delve into those issues. What does the Uniform Commercial Code provide in your particular situation? What are the facts, good and bad, that might impact your case in court? That's the number one issue. The second issue is always going to be in a supply chain matter. Is the supply of parts going to be disrupted if I don't go to court? If there is a risk that you don't get parts from your supplier and then you have to shut down your own customer, which may be an OEM, then you may not have any choice but to go to court to try to ask for a temporary restraining order and preliminary injunction. Because if you don't ship parts to your customer, the astronomical amount of damages, both actual money damages and what we call irreparable harm, could be off the charts and could threaten your business. Which gets into the third point of whether or not to go to court is, does this threaten the viability of a piece of your business, a business unit, or a key customer relationship? If you were to disrupt a relationship with one of your main OEM customers, and that could cause you to not get that next RFP for a new program, then it may make sense to go to court now as opposed to trying to wait for some resolution that may never come. The last consideration you want to make in terms of your initial assessment is, what's the cost-benefit analysis? Again, you've assessed the magnitude of the issue to your business, the monetary and non-monetary aspects of it, but what's it going to cost you in terms of going to court and getting a favorable result? Again, in these types of situations, you want to make sure you retain and use experienced automotive suppliers who know the business, who know the industry. You don't have to explain to them what PPAP means or what an SOW is. They know because they represent supplier clients every day. That's what we do with our clients. That's the benefit that we bring, and we'd be happy to meet with you further to discuss these issues. Thank you.